Hello, good afternoon, everyone. Everything is in order? Okay, great. My name is Elisa Jian. I am a associate of Fangda Partners, part of the dispute resolution team of Fangda Partners Hong Kong office. Today, in this session, we are getting close to the experts via a hot tubbing mock session. So hopefully this will be a very interesting and interactive session, especially now that it's after lunchtime, and I am sure a lot of you are probably also distracted with the US election. So thank you if you're tuning in. Thank you for tuning in today. In this panel, we will have, or in this demonstration, our actors will be Mr. Peter Bird, from the Berkeley Research Group. He will be acting as the, there he is, Peter. Hello. He will be acting as the respondents expert in this demonstration. Ms. Zoe Deng from Hogan Lovells. Hello, Zoe, joining us via Zoom. She will be the counsel for the respondents. We also have here live Joanne Lau, Miss Joanne Lau from Allen and Overy. She will be acting as the claimant's counsel. And last but not least, we have Mr. Zach Lee joining us remotely from Alex Partners. He will be acting as the claimant's expert witness. So these will be quantum experts. So let me, next slide, please. So in our today's session, we are going to, I don't see the next slide, but I am sure you're seeing the session outline. We're going to go through really quickly on a high level on what is expert hot tubbing. And then I am going to go through today's fact scenario, so for the audience benefit, so you will understand what is happening when we go through the mock session. And then, I've already introduced who is in the top today, our four panelists, and then I will be doubling as the arbitral tribunal as well during the demonstration. So, next slide, please. At the very end, we are going to entertain some questions about what you observed during the mock session, as well as hot tubbing in general. So make sure you click on the paper plane icon on the Legal Week website to submit your questions, and we will post them to the panelists. So next slide. Next slide. Yes, so quickly, there's a lot to be said about this, but at a very high level, expert hot tubbing, the objective here is to tender expert evidence in as efficiently as possible by streamlining the contentious issues. So how do we do this? We take the evidence from expert witnesses by having them confront each other at the same time. And rather than going through the traditional examination and cross-examination procedures, there are generally no standard guidelines or modalities on how to conduct the hot tubbing. It is really bespoke, and it can be customized according to the circumstances and according to the issues at stake. There are, however, some guidelines that you could refer to, the IBA rules on taking of expert witnesses, as well as the very useful and helpful CR protocol for party-appointed expert, in which they go through some matters. These guidelines go through some matters to consider when conducting expert hot tubbing, some sample directions for the tribunal, as well as the different modes of hot tubbing, whether it's arbitral tribunal-led, counsel-led, or expert-led. In today's demonstration, next slide, please. In today's demonstration, we would, I will go through which mode we are going to adopt. But let me go through this factual scenario first, so everyone is on the same page. So I've already introduced our cast of characters here. We have Cali Theme Park, which are the claimants, and the theme park us, which are the respondents in this arbitration. And then Ms. Joanne Lau and Mr. Zach Lee are going to a part of the respondents team. Mr. Zach Lee is the expert. Ms. Joanne Lau is the claimants counsel again. And the respondents will have Ms. Zoe Dong and Mr. Peter Bird as respondents counsel and expert respectively. The factual scenario, next slide, is the following. We're talking about theme parks here. So the respondents, theme parks are us. They own a number of theme parks. And the way that they operate the theme parks is by outsourcing it to a third party. So they acquire the theme park and then outsource the management and operations of the theme park to a third party. In this case, the third party is the claimant, Cali Theme Park. So Cali won a bid to manage the Wild World theme park. So, and a management and operations contract was signed between the claimant and the respondents. In this management operations contract, so the term of it is for 25 years with the option to renew for another 15 years. So in this M&O contract, the claimant was required to run the theme park in accordance with a certain level of a consistency with the respondent's brand. The claimant would also be able to recover all of the costs in operating the park, all the M&O management and operating costs. And then any remaining profits after the claimants recover the costs will be split 30-70 between the claimant and the respondent respectively. So what happened? Everything was smooth sailing, and then the respondent terminated the M&O contract. The respondent claimed that the claimant charged a number of costs, they're called the disputed costs, that were completely unrelated to the management and operations of the theme park. And also, they also claimed that the claimant failed to run the theme park in accordance with the respondent's brand. So then, as a result, the claimant started this arbitration, claiming for damages for wrongful termination. So next slide, please. So as I mentioned before, there are a number of different modalities for how to conduct a hot tubbing session or witness conferencing. In this session, we are going to demonstrate a tribunal-led conferencing mode. So, so first of all, the experts on each side will be allowed to present their positions on the expert issues. So there are two issues at stake: disputed cost and loss of profits for wrongful termination of the M&O contract. So the experts will each be allowed to present their positions. This is also to benefit the audience, so so you understand what the positions are. Then there will be a tribunal-led session where the tribunal is going to pose some questions to the experts and have them confront each other. And then we'll move to the counsel-led hot tubbing part, where each counsel from each side will be allowed to ask the expert questions. And we're going to split it up into two parts. One part is issue number one, and then we're going to move into issue number two. So that's how we are going to structure it. Okay, next slide, please. So the issues at stake, as I mentioned, there are two issues. One is on the disputed costs, on whether or not these costs were in fact related to the management and operations of the theme park. Claimants are saying yes, and respondents are saying no. Very, very simplified. And then the second issue are the lost profits. The computation of the lost profits, the experts differ on that, on the quantum of the lost profits. So now we're going to move into the proper mock session itself. Now I'm going to wear the arbitral tribunal hat here as well. It's no longer the moderator, just so you know. So let's assume in terms of the timeline of the arbitration proceedings that we have arrived at the hearing and the experts are about to give live evidence at the hearing. Expert reports have been exchanged, so everyone knows, all the parties know the expert's position as well as the tribunal. So, okay, so we'll start with the mock session. Good afternoon, everyone. So today, Mr. Lee, on behalf of the claimants, and Mr. Bird, on behalf of the respondents, are going to give evidence, their expert evidence on this arbitration matter. So the tribunal is minded to hear from each of the experts in a brief presentation. The claimant's expert might start. Mr. Lee, could you please start your presentation? Next slide. Next slide. Mr. Lee, you may start.
Thank you, Tribunal. Next slide, please. So my CV is attached to the Appendix 1 of the report. Just as a quick summary, I have 17 years experience, mainly specializing in the theme park industry, with audits of theme parks, financial due diligence of theme parks, operational projects concerning theme parks. I currently lead the firm's theme park practice. I'm also a lecturer at the London Business School, where I lecture on the economic theme park. So to quickly summarize the issue at hand, the respondent terminated this management and operation contract with the claimant. Claimant argues the contract was wrongfully terminated. On that basis, claimant are claiming two heads of damages. First, the cost that the respondents alleged claimant were not entitled to recover under the contract itself. I will set out analysis and demonstrate that it is reasonable to include these costs, in fact, do relate to the operation and management of the theme park. Second, the claimant is claiming for its loss of profit it would have been entitled to had the management of the operation contract not wrongfully terminated. But for respondents' wrongful termination, I estimate the claimants would have earned a profit of 5.7 million pounds. So with respect to the disputed costs, which the respondents allege are not related to the operation and management of the theme park here, and therefore not recoverable by the claimant, these costs total 237,810 pounds between 2001 and 2002. I've shown this in the first line of my table. And every year, the claimant prepares the respondent a statement of costs related to the management of the contract. And the second row in this table sets out the total value reported to the respondent by the claimant from 2001 and 2002. I understand that the respondents do not dispute the amounts that were indeed, in fact, incurred by the claimant, but rather these costs relate to the management of the theme park. So therefore, if they are related, then claimants are entitled to recover. As I set out in section 3 of the report, in order to gain comfort over the nature of the total costs incurred by the theme park, I've reconciled the value of annual reported costs prepared by the claimant in line 2 to the respondent and the audited financial statements in line 3. As you can see, they match perfectly each year. On that basis, the auditors appear to have audited or at least obtained comfort over the claimant's reported costs to the respondent. I've relied on two specific audit findings in making this conclusion, which are part of the audited cost. In fact, they do relate it to the operating activities. First, the auditors have explicitly stated in 4 years of audit statements that the sole business undertaken by the theme park during the period was operation and management. Had the cost not been incurred for the sole business activity, which is operation and management, then I would expect the auditor's opinion to have identified this fact. And I will not emphasize, I will not expect auditors to make the same mistake 4 years in a row. Second, and more importantly, the financial statements specifically refers to the management's maintenance of a robust control environment. and in particular on controlling the payments made by the business. Again, as an audit practitioner for 17 years, I do not find this statement, or I do not take this statement very lightly. It is obvious that auditors have tested controls surrounding the payment of the companies, and in particular with the ones that are responsible for the payment of business. And if it's not the case, then I would not expect such comments to be included in the financial statements. Based on those two audit findings, I consider it reasonable to conclude that these disputed expenses were related to the operation and management of the theme park and therefore recoverable by the claimant. Next, please.
Mr. Lee, in the interest of time, could the tribunal just ask you to go through your methodology here on calculating loss of profits rather than going through each of the components?
No problem. I've deployed a DCF methodology. I've forecasted the cash flows for the relevant periods and discounted back into the present value. There's an assumption in estimating the cash flows. In particular, there are two that are most relevant, and I will explain just very briefly. First is the average revenue per customer, and second is the max park capacity rate. In assessing these two assumptions, I've relied on the Top Theme Park Survey, which is an industry gold standard for park survey and actual performances. And I've compared my assumption to the actual results in the table below. I find it reasonable, and therefore I've assumed my assumptions. Thank you.
Thank you, Mr. Lee. So the tribunal would like to hear from Mr. Birch. Mr. Birch, you may present on the two issues. In the interest of time, would you just like to focus on disputed costs, your methodology, and just go over the, and then for the claimant's loss of profits as well, just go through your rebuttal to Mr. Lee's position, those 2 points, and try to expedite in the interest of time. Thank you very much. You may proceed, Mr. Berg.
Slide, please.
Next slide.
Next slide.
Next slide.
Okay, my name is Peter Bird. I'm a forensic accountant and I'm with BRG based in Singapore. BRG is an international firm of experts. We have over 1,000 experts and we have extensive experience of testifying. Next slide, please. I want to, as you said, Madam Chairman, I'm going to respond particularly on the issue of disputed costs. In his presentation, Mr. Lee makes very clear, as he does in his report, that essentially what he's relying on is the fact that these costs were included in the audited accounts, and he's relying on the fact that since the auditors have included in them accounts, they must have been validly incurred in connection with the operation of the business. I dispute that inference. The reason I dispute the inference is that in my experience, auditors take a view on materiality, and for items that are relatively low value, as these are in relation to the total costs of the claimant's operations, the auditors will rely on a sampling approach rather than a detailed analysis of each particular item. Therefore, in order for us to form a view, I take the view that we cannot rely solely on the auditors, and we have to take a forensic account to looking at the individual cost items. And in my view, in these 4 particular items, if you look at them in some detail, it's clear that they cannot be regarded as validly incurred in the management and operation of the theme park. In particular, we have the issue of Mr. Peters' credit card expenses. These are expenses on Mr. Peters' personal credit card. I take the view, therefore, that absent any express justification as to why the items on his credit card were incurred in relation to the business, that these should be regarded as personal expenditures and therefore not reclaimable. Secondly, we also have a number of items mounting to over 90 million pounds relating to travel costs. I find it bizarre that Mr. Peters and the claimant are trying to charge £90,000 to my client. Given that Mr. Peters lives very, very close to the theme park, it's not clear why he should have run up £90,000 worth of expenditure. The third item relates to related party transactions. Having looked at these more, these are related to catering costs, and they are with Mr. Peters' own personal catering company. In the M&O contract, it makes clear that the claimant has to provide catering services. These are there for services for which we have been charged, and it's clearly not clear why we're also being charged for Mr. Peters' personal catering services as well. These are related party transactions and should have been approved as such. They have not been approved, and therefore they also, in my view, cannot be regarded as cost associated with discharging the claimant's responsibilities under the contract. The fourth item we see relates to petty cash. Clearly we see that, and again, having looked at these in more detail, I see that these cover items such as video recorders and television screens. Again, this was money that was laid out in cash by Mr. Peters. Clearly, prima facie, I cannot see how video recorders and flat screen televisions can be related to management and operation of the park under the contract. And again, absent any express justification, which has not been provided, I do not believe that these can validly be regarded as costs incurred with discharging claimant's duties under the contract. If we can move on to the next slide.
Mr. Bird, in the interest of time, and because the tribunal only has questions for this session on the first three items of the chart on your slide, revenue per customer, park capacity.
Thank you. I certainly understand that, Chairman, and I'll just mention very briefly, I'm disputing a number of the principle of calculating damages is to compare the costs that would have been incurred with the costs that would have been incurred under a but-for scenario. Mr. Lee has put forward a scenario which is calculated the net present value of lost profits. To do that, he's had to make a number of assumptions about the future performance of the theme park. I am questioning some of the assumptions that he's using in his but-for scenario, in particular the average revenue per visitor to the park, and also the number of visitors to the park, which is reflected in his chart as a capacity rate. In my view, and I've looked independently at comments on TripAdvisor on the theme park and the average rating, it's clear that visitors to the theme park rate this theme park as below average, and on the basis of that, I'm assuming that the average revenue per visitor will be less than the industry average. I also note that attendances are declining. I note that competition is increasing on the island, and therefore I would also expect that average visitor numbers would go down. I've therefore made assumptions which differ from Mr. Lee's and lead me to lower numbers. I'll conclude there in the interest of time, Madam Chairman. Thank you for your attention.
Thank you to the experts. Thank you for the presentation. So now the tribunal, on the issue of disputed costs, the tribunal had a couple of areas of inquiry for the experts. So the first is on the methodology used to determine whether the disputed costs were related, in fact, to the management and operations of the theme park. So the tribunal has reviewed both experts' reports, and we would like to know from Mr. Lee whether you independently verified these disputed costs.
Thank you. I have not individually reviewed and verified the dispute cost as I was not provided with the transaction detailed.
So, Mr. Bird, is independent verification of these disputed costs important to coming up with an informed opinion on whether they are related to the operations of the park? What is your view on that?
Yeah, yes, in my view, it certainly is important. And I note that Mr. Lee, by his own words, has not reviewed them individually. I have looked at them, and I take the view that they are not chargeable under the contract.
And Mr. Lee, do you think that, to what extent did you rely on the Cali's audited financial statements to arrive at your opinion?
I fully rely on the Cali auditor's findings in concluding my opinion of dispute costs were related to the management, and in particular, is the control, the robust control surrounding the payment.
Mr. Bird, what do you have any response to Mr. Lee's
Yes,
reliance?
I would refer you, Chairman, to the comments I made that typically auditors in conducting their audit for items of this relative size would rely on a sampling approach rather than looking at each item in detail. And therefore, and because it's only been put in the accounts on a sampling basis, I believe you cannot rely on it and you have to take a more forensic approach.
So, Mr. Bird, you would not have relied on the financial reports to the extent that Mr. Lee did?
Sorry, is that
you would not have relied on the financial reports to the extent that Mr. Lee did?
No, I would not have relied on the financial report. I believe that one needs to look at the items individually on a forensic basis.
Mm-hmm. Mr. Lee, in your report, you indicate that these disputed costs are only a small portion of the park's overall running cost. So, do you know if this small portion of costs were verified by the auditors?
I cannot confirm that it was audited by the auditors, but what I can say is in a typical audit, the auditor will rely on the internal control of the company to sort of assess their risk, right? So I think for example, if a company has a very strong control, then the sampling will be less. If a company has a weak control, the sampling will be more. And in this particular case, it has been noted that the auditors essentially stated in the financial statements they have a very, very robust control, and in particular with their expenses.
But you would agree that the auditors would have taken samples to verify the accounts rather than verify all of the accounts?
I cannot confirm, but I think under normal audit, approach, you will test the control first, and depends on the control, whether they're effective or not, then you do your sampling test.
Mr. Bird, what is your response to Mr. Lee's comment that on the auditor's approach?
Thank you. Sure, Chairman. Look, Chairman, I agree with everything that Mr. Lee says, and his description of what auditors do is certainly a very reasonable one. However, Mr. Lee, given what Mr. Lee has said, this does not rule out the possibility that auditors, through the process which he's described very well, will allow through certain costs which cannot be justified in terms of the performance of the contract. Mr. Lee has made clear that there are potential gaps, and I believe that in this case, things have fallen through the gaps, and costs have been charged that should not have been charged.
Thank you. Those are all the tribunal's questions on the disputed cost, and now the council will have an opportunity to question the experts. So we will start with Ms. Lau, counsel for the claimant. Ms. Lau?
Hello, Mr. Bird. My name is Joanne Lau. As the chairman mentioned, I'm counsel for the claimant, and I have a few questions for you today. Thank you for being here with us. At paragraph 3.3 of your expert report, you stated that the fact that the audited financial statements state that the sole business of Kali Theme Parks was the operation and management of the Wild World theme park does not necessarily mean that the disputed costs were definitely incurred in relation to the management and operation of the theme park. So to put it more simply, is it right that what you are essentially saying is that the disputed costs could have been unrelated to the management and operation of the theme park?
They could have been related to the management of the theme park. However, looking at the actual nature of the costs, I do not believe that they were related to the management of the theme park.
Mr. Lee, the tribunal would like to hear from you on whether you, to the same question, basically your response, on whether you would agree that it is possible that the auditors did not verify this disputed cost.
So I think will go back to my point on the control of the company, right? Because I think with the auditors, if there are robust control in place, these controls should be able to catch whether these are personal expenses or business expenses. So in my view as an audit partner, if there is a robust control surrounding the business payment, and in particular, it's a very robust one, then I will expect the likelihood for these disputed costs to be related to management operation. Otherwise, the controls are ineffective.
But there's no way to know at this point in time whether the auditors verified the disputed cost.
Yes, unless we obtain the
right.
Actual audit working paper, I'm unable to confirm.
Understood. So there's no way to verify that. So then in that case, the statements that Ms. Lau just put to Mr. Bird, in the same way that they could have been related to the management and operations of the park, it is also possible that they could not have been related to that. Is that correct? It is possible that they could not have.
It's certainly my view that it is possible that they were not related to the management and operation of the theme park. And in my view, given the nature of the expenses, they were not related to the management and operation of the theme park.
Okay, thank you, Ms. Lau. You may proceed.
Mr. Bird, I would now like to learn a bit more about the approach that you've taken in, you mentioned reviewing the disputed costs, and you stated that you took a forensic approach. So I'd like to look at each of the disputed items. The first one is payments made to clear Mr. Peters' personal credit card. And in your report, you stated that Theme Park R Us has challenged these costs on the basis that they are payments for Mr. Peters' own expenses. And based on that, you reach your conclusion that the inclusion of these costs is inappropriate. So my question is, did you simply rely on Theme Parks R Us challenge? And have you personally reviewed each of these payments from his personal credit card in reaching your conclusion?
I have taken the view that had they been business expenses, he would have charged them to his business credit card. However, he has charged them to his personal credit card, which I take as prima facie evidence that these were personal expenses.
And
that is the basis on which I've made that judgment.
And do you accept that if his personal credit card was used for payment for business purposes, then would you be of the opinion that those costs would be appropriately included?
Yes, in my view, it is possible that he had paid business expenses with his personal credit card. I must say that I personally have on occasions paid business expenses using my personal credit card. However, I have then provided a full explanation to BRG's auditors of why this is the case. So yes, it is possible, but in that case, I would expect a proper explanation of why this has been done, and no such explanation has been offered in this case.
So the tribunal here has a question for both experts on whether it is common practice in this industry, from your experience, for the usage of personal credit cards to pay for these business expenses. Presumably in this industry, for a sophisticated company like Parks R Us and Cali, there would be business credit cards and business expense accounts, right? So the tribunal would like to hear from both experts on this question. Mr. Lee, you might go first.
Thank you. I think it's fairly common, and for the reason being that, at least so far in my career, that all my corporate credit cards has been American Express. I'm not sure if it's the same for Mr. Bird. There are numerous occasions where vendors don't accept American Express, so I have to use my personal credit card and then claim it back. So I think to that degree, I think all of us have done that in the past, which is using our credit card, personal credit card first, and then claim it back through the reimbursement system with the firm.
What is your response to Mr. Bird's comment just now that after using personal credit cards, there has to be full justification and full evidence provided on the reason why those expenses were incurred? It appears that the claimant did not provide that. What is your response to Mr. Bird's comment on that point? Mr. Lee?
Was that a question to me or Mr. Bird?
To Mr. Lee. What is your response to Mr. Bird's comment that even after using your personal credit card for business expenses, you would ordinarily provide full justification of these expenses? And it doesn't appear that this has been the case here. So what is your comment on that point?
Yes, I think that is a very common approach. However, that level of detail was not provided to me nor Mr. Bird, as I understand it from his report.
All right. Okay. So Ms. Lau, you may proceed.
Turning to the next item of the disputed cost, the travel expenses. My question to you, Mr. Bird, is a similar one. Is your opinion based on the challenge of your client, Theme Park R Us? And have you actually conducted an independent review of the costs to verify what those travel expenses were in fact incurred for?
Yeah, the answer to that question, Chairman, is that I've been instructed by the client that they have made this challenge, and I have seen, I agree in principle with the nature of the challenge, and I would therefore expect that I would have been provided through the discovery process with information that enables me to take a view on whether that challenge is valid or not. I have not been provided with such information, and therefore I have to look at it on a prima facie basis, and prima facie, the claims by my client are entirely reasonable.
And you stated in your report that you believe they are of a level which would suggest that they clearly do not relate to Wild World theme park. I want to ask you, what is the basis for saying that? As we understand it, you are giving evidence today in your capacity as a quantum expert, and you are not a theme park industry expert. Is that correct?
That is correct. Chairman, the answer I will give to that question is that I do not need to be a theme park expert to state that travel expenses of £90,000 for someone who lives next to the theme park would not be validly incurred in relation to operation of the theme park. I do not need to be a theme park expert to express that view. I would express that view if it were another industry. I would express the view if this had been submitted by an employee of BRG.
On this point, the tribunal would like to hear from Mr. Lee. Whether or not there's expertise in the theme park industry, do you agree or disagree with Mr. Bird's observation that that Mr. Peters' travel expenses were simply unreasonable, given the fact that he actually lives very close to his place of work at the WW theme park? Do you disagree with the reasoning of Mr.
I think I agree with Mr. Bird that this doesn't take a theme park expert to figure this out. In the sense of, I live 5 minutes to the office. I rack up tens and thousands of flights and hotels a year, traveling around for meetings to meet with my clients. And I think there's two things here, right? So the travel expenses spiked 8 times from 2001, 2002. So I think auditors will likely to pick that up because that's a significant change. So that's for one. So they would have looked at this. I think the second thing, perhaps, as I noted in note 13 of my report, is that between 2001 and 2002 is when the theme park decided to switch strategy, going from a high-end theme park to a mid-sized theme park, at the instructions of the respondent, actually. So there were significant discussions that happened between those period where the travel expenses spiked. So based on those, I don't find it unreasonable to say that these expenses are for business operations. And I refer back to the controls that if these are not business expenses, they would have been flagged. The controls are identified by the auditors because of the spike in the amount.
Mr. Bird, what is your response to Mr. Lee's comments just now?
Chairman, I congratulate Mr. Lee on telling a very good story, and it's certainly a story which may be true. However, it remains a story. There is no hard evidence for this, and I refer you to the fact that Mr. Lee continues to ask us to rely on the fact that the audit said the controls were good. However, the audit did not say that they have looked at these particular items of expenditure, and they have confirmed that they are validly incurred in relation to the management and operation of the theme park. Mr. Lee tells a very good story, but there is no basis for the story.
Thank you, Mr. Bird. I think in the interest of time, the tribunal would like to move on to the Respondents' Council's questioning.
Thanks very much, Madam Tribunal. So, Mr. Lee, you have acknowledged in your answers to the tribunal that, you have acknowledged in your answers to the tribunal's questions that you solely relied on the audited reports to reach your conclusion, and that you did not verify these costs independently. Is that correct?
That is correct.
But nowhere in the audited reports did the auditors expressly say or verify that they have looked at the disputed costs or that these costs were incurred for the management of the park. Is that correct?
That's correct. They did not explicitly say that.
So you acknowledge that your conclusion was reached based on several assumptions, which are not originally in the audited reports?
I wouldn't call them assumptions. I would call them based on my experience as an audit partner. Those were reasonable, would have been done at the time.
But in the process of preparing your reports, you could have easily requested the necessary documents, including the detailed expense records from your client, or a confirmation from the auditors regarding whether they have checked the disputed costs, to just confirm the assumptions you reached based on your experience. But you did not do either of this. Is that correct?
I didn't think it was necessary. If we were to rely on the auditor's findings, then why were you putting more doubts on the findings?
Mr. Lee, the tribunal would like to circle back to this, to your reliance on the auditor's report that there was a robust control environment adopted by management. What is the meaning of that in practical terms?
Perhaps instead of using these jargons or accounting jargons, let me just, for the benefit of the tribunal and everyone else, I'll use more of an easier and simpler example to demonstrate my point. So if I'm an office building manager and I have a third-party security team that checks my building security every year, and every year this consultant issues opinion saying, my building controls are great, in particular with the access controls of people coming in and out. And the only people that were coming in and out were the people that work in this building. Now, 4 years after, perhaps there's a concerned stakeholder tells me he has seen people coming out of the building that he doesn't recognize. And he thinks there's a breach of security. I hope the tribunal can understand where I'm coming from is that the appropriate response, and it would be reasonable to rely on the findings of these security experts and their independent security consultants in helping clear the concerns of the stakeholder. So similarly in our case, based on the audit procedures and auditors' findings that have been done, it will be likely that these costs were related to the business purposes. Otherwise, as I mentioned earlier, I would expect the auditors to find it, and if not, the controls, the robust controls are in place to check it.
Mr. Bird, what is your comment to Mr. Lee's response on robust control environments? What is the meaning of that to you?
Thank you for giving me the chance to comment, Chairman. What I would say is that to, again, paraphrase further what Mr. Lee is saying. What he is saying is that because the auditors have said there is a robust control mechanism, that we should assume that this control mechanism is 100% perfect and that things cannot get through the system. Now, as an auditor, when I say there's a robust control mechanism, I do not claim that it is 100% foolproof. In exactly the same way as when I issue an audit report, I cannot say there has been no example of fraud in the company whatsoever. All I can say is that it is, and to use Mr. Lee's words, robust. However, that does not mean that things cannot fall through the cracks. And I believe that in this case, wrongful expenditure has fallen through the cracks. Hong Kong has a very efficient police force. That does not mean there is no crime in Hong Kong.
Mr. Lee, your response?
I think there are really sort of three main issues for the tribunal to consider here. I hope Mr. Burr and I can agree on and disagree to the positions as we have different positions. And I think really it's the first is, neither Mr. Burr and I have actually individually verified these costs as they were not provided to us. You have heard from both sides. I think, to be honest, the quickest way to put this issue to rest is perhaps for the tribunal to order the claimant to produce these actual records. So the question or the real situation we're dealing with here is that absent of the actual records, perhaps Mr. Burr and I both would have preferred, what evidence can we really rely on in determining these costs are related to the operation of the business? So I have relied on two things. The auditor's findings, in particular to the controls surrounding the payments that are being robust, and my understanding of the auditing procedures as I'm the theme park audit expert. And perhaps Mr. Bird has relied on two things as well, which is the table provided the respondent and various um, supplementary explanation provided the respondent in making his conclusion. I think that lastly, what's important is, I think I want to highlight, if we do trust auditors have done their job, in particular with checking the robustness of control, then we should rely on their findings. Mr. Bird does not dispute that the auditor's findings are incorrect. His opinion is that the auditor's findings cannot be relied on for the purpose of checking the nature of the expenses. In my view, this opinion reflects perhaps his understanding of the audit process, and which contradicts with my view as an audit professional.
Thank you, Mr. Lee. In the interest of time, we should probably move to issue number 2 of the lost profits. Ms. Lau, you may ask the expert the questions first.
Mr. Bird, for the second issue, I understand that you rely heavily on the TripAdvisor ratings in your expert report to conclude that the company is operating at a below average quality. And I want to ask you, as a rating and review platform, is it right that anyone could leave a comment and a rating on the website?
Yes, that is correct. Anyone can do that.
So it's not a particularly scientific platform. Sources are not verified. Do you agree?
Chairman, I should have said that as well as being an accountant, I also train as a statistician, and as statisticians, the very bulk of our profession is the concept of the law of large numbers. If you take a sample of a large number of people, you will get a sample mean that in statistics we normally say that can be regarded as an estimate of the population mean. In a very similar way, one doesn't require every single respondent on TripAdvisor to be a particularly reliable person. What one relies on in looking at TripAdvisor is the fact that there are many thousands or tens of thousands of respondents, and the average rating reflects that. So therefore, while I'll accept that not everyone who is responding will necessarily be a bona fide user, in my experience, and I think it's well established in the industry and many other industries, that TripAdvisor ratings can be regarded as unreliable. My apologies, Chairman, as reliable.
Mr. Lee, actually for both experts, the tribunal would like to understand from both experts the relevance of websites like TripAdvisor and their ratings in terms of assessing the general reputation of an establishment like the worldwide theme park. So, Mr. Lee, you might go first.
Yes, I think if the question is assessing the reputation, perhaps I will agree with Mr. Bird that you are assessing the reputation of theme park. But in terms of using TripAdvisor to value theme park, the only comment I can make is really I've never come across in anyone in this industry or any mergers and acquisition deals that I've referred to TripAdvisor as a reference point. As far as my expertise and my experience as a theme park expert are concerned, the gold standard in benchmarking performance and providing financial due diligence in a buy-sell scenario, it's by far the top park survey. And I want to emphasize that this is a highly regarded industry publication.
Mr. Bird, the same question for you.
Well, I hear what Mr. Mr. Lee says. However, this is something that is not reflected in his report. I have not had access to the particular server that he is talking about. What I have relied on, though, is TripAdvisor, which, although Mr. Lee may not describe it as the gold standard, however, it is the common standard, and I believe that TripAdvisor it's certainly reasonable to rely on TripAdvisor.
Thank you. Ms. Lau, you may proceed.
Mr. Bird, just one final question on this point. Other than TripAdvisor, have you considered any other websites, industry publications, surveys, etc.?
I have not, because I was not aware of any other relevant website.
Mr. Lee, on this point, on the sources of input for your model, did you also consider or relied on surveys other than the theme park survey?
I didn't consider the need to, as is commonly referred to in my experience. The metrics referred within are used for evaluation. That is, again, the gold standard in the theme park industry. So I've not relied on sort of what Mr. Burr sort of the common factors such as websites such as TripAdvisor, because I just find it more credible to rely on top theme park survey. For example, if you're looking at restaurants for dinners for particular important things, you'll go on Mission Star. You wouldn't go on Yelp and OpenRice, for example.
Chairman, apologies for interrupting, but I do exactly what Mr. Lee says you don't do. I do indeed rely on Yelp, as do all my friends.
Thank you, Ms. Bird. You may proceed, Ms. Lau.
Mr. Bird, you mentioned in your expert report that there were increasingly negative comments about the theme park. This is your impression from simply browsing the website, is that correct?
Sorry, Chairman, I didn't quite hear the question, but I think you're saying, what was my impression? And my impression was clearly that this is this is now a second-rate theme park, and therefore it will get below average attendances, and customers will be at the bottom end of the market and will essentially have low expenditure at the theme park. That is the impression I've got. And I've relied on that impression in my report.
You haven't conducted any study to look at the ratio of positive comments to negative comments, have you?
Yes, I have looked at the ratio of positive and negative comments, and the majority of comments are negative.
Mr. Lee, same question for you. Have you reviewed the comments on the TripAdvisor website, the negative comments on the park?
I'll be frank, I did not review them, but I've reviewed the ones that were quoted by Mr. Bird in his report. I think I just have to have two observations here. The low rating, it's already there, right? They've changed their strategy in 2003, and the ratings has been consistently low. As a matter of fact, as Mr. Bird points out, it's the lowest 25% of theme parks around. But nonetheless, if you actually look at the actual performance of the theme park, it's performing as expected when you switch from a high-end theme park to a low-end theme park, in the sense of a reduction in the average spending, but an increase in the park attendance rate. So in that regards, I think it's completely reasonable that it has a low rating, because it already reflects in the actual numbers as of at the end of 2013 and 2014. So my second point is, Mr. Burr, as he mentioned, it's his impression that this park will continue to decline in terms of both average revenue per visitor and also attendance rate. I take the opposite position. I expect the attendance to increase and the revenue to maintain as where it is, because the pool ratings has already been factored in the actual numbers in 2003 and 2004.
Mr. Bird, your response?
Yeah, I think that Mr. Lee has very well explained the difference between our two positions. He is saying that the tendencies have gone down, but as a result of the change in strategy, and he now expects them to continue up. He now expects them to go up. I rely on the same data that the tendencies have gone down, but in my view, they will continue to go down. And the reason for that is that I believe that the market does not respond instantaneously to the change in the market positioning. There are families who may have visited the theme park 2 years ago when it was a high-end theme park. They had a wonderful time. In 2 years' time, they're going to go back to the theme park because they are expecting to have a wonderful time. They will be disappointed because the theme park has gone down market, and they will never go back again. Therefore, the decline as a result in the change of strategy will not come through immediately and therefore be followed by a recovery as a new set of customers. It will continue because customers do not instantly change their view of the theme park because they aren't visiting the park all the time. So there is a clear difference, as Mr. Lee has actually explained, between his view and my view. Chairman, I think my view is the better view.
Thank you, Mr. Bird, for that. In the interest of time, we are going to move on to the final couple of questions from the Respondents' Council.
Thanks very much, Madam Tribunal. So, Mr. Lee, you just acknowledged that you used the average numbers in 2005 from the theme park survey as your benchmark for projecting the revenue from 2005 to 2040. Is that correct?
Sorry, it's correct as I first checked the average and also looked at the actual results.
So do you agree that the survey you relied on would include theme parks performing very well and theme parks performing poorly?
That is correct.
And unlike Mr. Bird, you did not take the second step normally adopted in damages projection. That is, you did not adjust or refine the benchmark numbers from the survey, taking into account the specific circumstances of this particular park, which is admittedly a poorly performing park. Is that correct?
I think that depends on what your definition of poorly performance park. If you're poorly performing based on the rating, no. But if you're poorly performing against the actual data, you'll see the data is actually trending upwards.
But no matter what the definition of the poorly performing is, you did not really take into account the specific circumstances of this particular card in refining your projection. Is that correct?
Well, I looked at the actual data. The data speak for itself. So I think that is the specific I refer to in my report.
So I understand that you adopted this approach based on your experience in evaluation. So now let's go back to UCV and looking at your experience. So Mr. Lee, you said in your CV that your specialty is actually in auditing and financial management analysis. Is that correct?
That's among the few, yes.
Yeah. So your CV does not mention any experience in damages or quantum valuation, which is a very distinct area from auditing and financial analysis. Is that correct?
This is my first time testifying on damages, but I have a deep understanding of the economics of the theme park, as I've demonstrated on my lecture at the London Business School.
but there are two different aspects of expertise. So one of them is analyzing possibly the existing data and also the adjusting the operational strategy. The other one actually requires the ability to establish a projection model for future operation. Do you agree?
I think that depends on what your definition of economics is. I think everything is driven by economics or modeling. So if your definition of economics is not that, then I agree with you.
So the tribunal is
Thanks
going to
very much,
interject
Mr.
here, counsel and experts. We have ran out of time for this session. Thank you very much for your questioning. So let's just end the mock session here. So that is the end of the demonstration of the hot tubbing session. And now let's entertain some questions from the audience. If there's any, let me just check. There is one question. Oh, it's quite long. Two questions, long questions. Great, thank you for that. Let's keep submitting the questions. Let me just first ask our panelists on their views on how this mock session compares to a real life scenario. Why don't we start with Zoe, since I cut you off?
Not only in real life, the issues involved are going to be much more complicated. And I think our experts will have more like underlying data. So the issue about the disputed costs would not really appear in a real life scenario because they will have the documents to prepare their report. And I think also for real life, the whole process can be more chaotic because I think Eliza did an extremely good job in controlling the process. But in real life, it possibly will be more contentious, and there are going to be a lot of attack on the experts, like expertise, and also whether experts actually conducted sufficient independent analysis to produce the expert report. I think that's my general impression.
Thank you, Zoe. Comments? Other comments? Joanne?
First of all, the setting is very different. That was something we joked about right before the conference. But even though the setting is different, and as Zoe mentioned, this kind of fact pattern, we may not have it in real life, but I do think the mock session just now gives a flavor of what hot tubbing would be like, because I did observe, so for example, when Zoe is doing the more cross-examination type questions, the responses that we get from the experts were more yes, no, and shorter answers, whereas for the tribunal's questions, they are often open-ended, and those kinds of questions really do bring in longer responses, more opportunities for the experts to elaborate, and you can make sure that the experts respond to each other. So in that sense, I think that also reflects real life situation as well.
Thank you. Zach and Peter, comments on your end from the expert's perspective?
Yeah, can I make one comment? What I would say is that compared with our experience today, compared with my experience of hot tubbing previously, is that another difference is the fact that we're doing it on Zoom. Both myself and Zach are on Zoom, rather than sitting next to each other in a chair. And in my experience, the fact that the two experts are sitting next to each other with the tribunal in front of them, asking them questions, creates a bond between the experts, so that they actually almost respond more as a team than as individuals. So I think my experience with Zach today, compared with my experience of hot tubbing in practice, we've perhaps been more adversarial to each other than we would have been had we been sitting next to each other. I think one of the benefits of hot tubbing is that it's just the theatre of it. It forces the experts to engage more with each other, and in a sense, it's the experts together helping the tribunal. And I think that's one of the great benefits of hot tubbing, is it does get the experts in their true role, which is to help the tribunal. Now, obviously, it doesn't always operate like that, but in the best hot tubbing, it does, and it does tend to help the tribunal discover the key issues between the experts, and both experts are together collaborating in helping the tribunal to drill down into what the key areas of difference are.
Zach?
I think it really comes back to what is the purpose of hot tubbing and expert witness, right? Like much like Peter said, it's to help the tribunals. It's to help, in particular, it's to help the tribunals to identify the key disagreement and an agreement among the experts, right? So a lot of time these can be done through a joint statement. And I'm sure in all of our experiences that sometimes you get apples to oranges with joint statement. Instructions are different and they're not just really, you can't really compare them. So in that event, I think the hot tubbing really helps. It helps the tribunal to narrow down the issues they need to decide on, ultimately benefiting the tribunal in this process, help them understand which are the more important issues, which one are less important, and what are the positions from each expert on this.
For the experts, have you encountered in the past, how often do tribunals provide you with a list of issues that they want to hear from, that they want to hear on at the hearing? Do you see that happening? So right before the hearing and for the witness conference in session, the tribunal will send you a short list of questions or issues that they would like to hear from. Do you see that often, or have you seen that? Which would help further narrow the issues.
I guess in my experience, that usually comes with a joint statement.
Mm-hmm.
I guess perhaps what we do end up is a list of issues from the tribunal after the hot tubbing, essentially listing out perhaps each position from the expert and how that impact our analysis. Perhaps then there's another round of exchange in the pros hearing briefs.
Yeah, in my experience, when I've been hot tubbing, the tribunal hasn't provided the list of questions in advance, but as Zach says, the process of the tribunal asking the experts and asking the experts together helps draw out again exactly what those issues are.
Great. So let's just take the questions from the audience. So hot tubbing has the advantages of having evidence of experts simultaneously, facilitating the tribunals in sorting out the common grounds and differences. So there are, we discuss a number of pros. What are the cons, basically? What are the drawbacks in adopting hot tubbing, if any? And do they depend on the nature of the dispute and the degree of disagreements between the experts? So maybe Joanne, you can go first.
As counsel, I see two main drawbacks. The first one is when you're simply doing cross-examination of an expert, then the counsel is really in control of the flow and where the questioning is going, whereas once you have hot tubbing, then it really opens up all kinds of possibilities. So the counsel is less in control, even though it may benefit the tribunal a bit more. And the second drawback is that hot tubbing, I don't think it's for everyone. As Peter mentioned, sometimes with experts sitting side by side, it may become less adversarial, which is a good thing. Sometimes, though, I've also seen situations where people have very strong personalities, and when you put two strong personalities together, the result may actually become even more adversarial. So it does depend on the personality a little bit, and then that may be a drawback in some sense.
Do you usually, question for you and Zoe, do you usually conduct the hot tubbing in a cross-examination style, or sometimes you find that it might be helpful to also examine your own expert directly rather than cross-examine the other side, or just do it interspersed?
Yeah, the format that I usually see is the hot tubbing, the witness conferencing session is usually driven by the tribunal, and where we want direct evidence, direct examination, that's usually in the form of the opening presentation by the experts. And then the session itself for counsel, it's usually focused on cross-examination. But I know there are lots of different kinds of formats. So,
Zoe, what have you seen?
I think one of the most effective hot tubbing I've experienced is actually that the tribunal initiated a private meeting with the experts without the legal counsels. And they came out with the list of issues and also a joint expert statement. And later, the councils will have the opportunity to look at this list of issues and a statement and to prepare for the cross-examination. Although it's strictly speaking possibly is not a hot tubbing at trial, but I think the effect of that practice is that the tribunal and the experts can sit together and figure out the real disputed areas. And also when the councils are not there, the experts are more open about what they're going to say because they don't have to worry about being misrepresented by the lawyers at the trial. So it's a very good practice to narrow down the real issue in dispute. And later at a trial, the councils will have the opportunity to do cross-examination to present their case. I think that's possibly one of the most efficient way of dealing with things.
Thank you. So last comments from the experts on from the experts' perspective, what do you dislike about the hot tubbing session, and what do you think are some of the drawbacks?
Well, I'll go first. I mean, there's nothing I dislike about it. I mean, my experience of hot tubbing have all been positive. I did find interesting what Zoe says about having private hot tubbing, as it were. I've not personally experienced it, but it certainly sounds like a good idea, and I would very much welcome the chance to do it if such an opportunity arises.
Zach?
Councils will strongly object to that.
Zach, any?
I think I'm united. I present a united front of Peter on this. I think for the hot tubbing, it is really sort of giving the opportunity to experts to work out together and work for the tribunal in that sense. I think in particular, it really boils down to how can you narrow the issues, right? I think that is, I've seen where in one of the witness hot tubbing, we had 11 sort of different disagreements, and the tribunal literally just bulldozed through 11 disagreements, and then we only had sort of 5 disagreements by the end of it, within like half an hour. So I think it's, in my opinion, here, tribunal, there's a reason why tribunal is asking for more for hot tubbing. Clearly, they do see the benefit. Otherwise, this trend would stop already, right? So they do sort of see a need to sort of listen to the experts, perhaps either in with lawyers or without lawyers' involvement. And I think that is really sort of the key to this. Perhaps it's tribunal feeling that they're not getting, and this is pure speculation, they're not really getting the answer they want directly from the cross-examination.
Thank you. And with that has to be the last comment. We are 2 minutes and 7 seconds over time, so that wasn't too bad. Thank you very much for tuning in, despite the very distracting election results happening. And if you would like to see a replay of this, it's going to be on YouTube. Thank you very much for tuning in. And thank you to our panelists for that very insightful mock session and their responses to the questions. Thank you. Have a good afternoon.
Hi, welcome back. Thank you guys for sitting through three wonderful panels. We're on our last but not least fourth panel on conflicts of interests on experts, along with other topics that our moderator, who I'm here to introduce, will explain to you. So if I could have the Zoom over to Ms. Inwa Kwan. There we go. Inwa, can you hear me? Cannot.
Yes, very well.
Oh, why are you leaning down? Oh, no, wait, that's Ara.
Um,
Oh, it's very cute. Hi, Ara. Sorry. It's been a while. Hi, Inwa. How are you? Good morning. No more? Inwa? Technical difficulties. Frau Kwan? Wo bist du? So, as we wait for Ms. Kwan to come back, I suppose actually let me give you some details that she probably will give you also. For our audience, the same thing goes for this panel as well. If you have any questions, please go to the Hong Kong Legal Week homepage where there's going to be a button where you can insert your questions. And Inwa will take the questions either during the panel discussion or at the end if there's time. And we've lost her. Well, hello. We have Lars from Japan, Ara in Seoul, Matthew and Sarah here in Hong Kong. Oh, you can't see them, sorry, but you'll see them later. I love this. Oh, there we go. Hi,
Hello,
Inwa.
sorry for the interruption. I think I was frozen out.
That's okay. I actually just said good morning. How are you doing? Everything okay?
Everything's good.
Everything's good in Vienna, yeah? Slowly getting back to norm?
I hope so. It didn't really feel so this morning on the metro, but I'm sure we will recover soon.
Well, our hearts, our prayers are all with everyone there. I am going to now pass this over to you. Just to let you know, I have briefly introduced how the audience can ask questions, but I'm going to leave the introduction of the panel and our lovely panelists to you and let you take it from here. Enjoy.
Thank you. Thank you very much, Sherlyn, for the introduction. Hello. As was introduced, I'm Inwa Kwan. I'm going to be your moderator today for the 14th Annual Generations in Arbitration Conference, organized by Mood Alumni Association, together with the Department of Justice of Hong Kong this year. As you can see, although two of our panel members who are present at the conference venue, this conference is virtually brought to you. One quick housekeeping point before we get started. Well, I see that it seems that it is controlled by the organizer. In case it isn't, please mute your microphone at all time during the session. So you've joined the last panel of today, a fresh look at conflicts of interest. What about the experts? We have 4 panelists. I will add further lines to what Shirley has introduced briefly before we hear from them about the conflicts of interest involving experts, how to identify them, how to best address, avoid such conflicts. Let me briefly introduce the 4 panelists to you. We have the privilege of having leading practitioners of international arbitration to hear from today. Starting first with Ara Cho, partner at Peter & Kim, a Korea-Swiss dispute resolution focused firm. She's a Korean attorney with a decade of experience advising clients in international or commercial, as well as investment arbitration cases, with specific expertise in construction and project disputes. She's based in Seoul and currently virtually connecting from her office. Next, we have Lars Marker, partner at Nishimura and Asahi. Lars is a German qualified lawyer who has been previously with one of the market-leading German firm, and before that has worked in New York for a couple of years before joining the office in Tokyo. He's one of the few go-to lawyer or arbitration practitioner known to be Asia expert in Germany and Greater Europe. Lars and I had shared a table discussion last year in Seoul. before the pandemic. And it's very nice to see him again thanks to our virtual conference. Next, Sarah Thomas, dispute resolution partner at Morrison Foster in Hong Kong, who joined us from the conference venue. She has experience with arbitral proceedings brought under all major Asian arbitration venues and has deep understanding of the legislation and institutional rules of Asia Pacific region. She is recently recognized by Asian Legal Business to its 40 under 40 list of outstanding legal professional of 2020, just to mention the latest news. Lastly, Matthew Townsend. Matthew is a counsel to Fangda Partners as international arbitration and dispute resolution specialist. His focus includes energy, technology, and infrastructure. Before being based in Hong Kong, he has previously worked in Beijing for 5 years and very impressively speaks Mandarin Chinese and often advises clients on matters related to China. Besides advising clients, for Farah.
So it seems like Inhua is frozen again.
Do we still have Ara on the line? Because as I understand it, so this is Matthew, by the way. As I understand it, the first part of today will involve Ara giving a presentation on the reason why we're here, which is the principles behind the independence and impartiality of experts and why it's so important. Perhaps Ara could commence that now while we wait for Inhua to get back on.
Thank you. Thank you very much, Matthew. I'm not sure when I was cut off. I went on for a while, I think. But thank you. If I assume everyone heard the introduction of our panelists, at least briefly, I hope. And we could start with our first question without further ado. And thank you, Matthew, again, for asking the organizer to pull up the slides that Ara prepared. And Ara, I would turn to you for a first question. How do we identify or measure conflicts of interest, especially involving experts?
Sure, thank you. Thank you, Inhua, for your introduction. And I am honored to speak in this conference with this interesting issue. The panelists all together, we thought it would be helpful to go through some of the key standards and rules before we get into more specific issues. So I'll just briefly, there are just like 7 slides, so I'll just briefly go through them to just to kind of give you the idea or the roadmap of what kind of issues that can arise from the conflicts of interest for the experts. Can you move to the next slides, please? Yeah, thank you. Okay, so first of all, I just wanted to briefly touch upon some conceptual difference between the conflicts of interest for arbitrators, counsels, and experts. Please understand that this is a very, very rough diagram. Just want to get the idea of the comparison between these different actors. So when we talk about the arbitrators' conflicts of interest, what we are trying to avoid is to protect the parties from biased decision. So the core of the rules or standards is that there should be an independence, impartiality of the arbitrators, and the integrity of the arbitration procedure should be kept. Whereas when we talk about counsel's conflicts of interest, the rulemakers are trying to protect the client's interest, actually. They are requiring counsel to comply with their fiduciary duty of confidentiality, all those towards their current and past clients. When it comes to the experts, I think it is quite interesting to note that party-appointed experts actually have both features of what I just described for arbitrators and for the counsel. So they are required to be independent. So that's why close relationship, why they're required to disclose some of the relationship with the appointing or the opposing parties. And that, assuming that that should be avoided. But at the same time, they have certain type of fiduciary duty towards their appointing party or the client as well. So there are, I think, these two aspects which makes it different from both arbitrators and the counsel from the perspective of conflicts of interest. With that, I will now turn to the specific rules and standards. Next slide, please. So there are two major rules basically, and the first is the IBA rules on the taking of evidence on international arbitration. And the Article 5 requires the experts must disclose his or her present and past relationship, if any, with any of the parties, their legal advisors, and the arbitral tribunal. And it also states that experts must confirm his or her independence from the parties, their legal advisors, and the arbitral tribunal. However, we have to note that there isn't any examples or guidelines yet to set out what kind of relationship and to what extent will be considered as existence or appearance of the conflicts of interest. And the question still remains whether the IBA guidelines on conflict of interest for arbitrators will directly apply the same way to the party-appointed experts. Next slide, please. And the second one is the CR Article 4 of the CR protocol. The similar contents, it requires that an expert's opinion shall be impartial, objective, unbiased, and uninfluenced by the pressures of the dispute resolution process or by any party. And it also says that experts must disclose any past or present relationship with any of the parties, the arbitral tribunal, counsel, or other representatives of the parties, other witnesses, and any other person or entity involved in the arbitration. And this protocol, the same article subsection also provides that the payment by the appointing party of the expert's reasonable professional fees for the work done in giving such evidence shall not of itself vitiate the expert's impartiality. That's the addition from what the IBA rules say. Next slide, please. Then actually those were the two major rules that we can consider for the arbitration proceedings. But overarching, there is this code of conduct for each relevant professional organizations that define some of these independence requirements. Next slide, please. So just a very few examples, like American Society of Appraisers Principles of Appraisal Practice and Code of Ethics. They provide that it is the appraiser's obligation to present the data, analysis, and value without bias, regardless of the effect of such unbiased presentation on his client's case. And similarly, UK Institution of Civil Engineers Guidance Note for Rule 1 says that, provides that when acting as expert witnesses, members must be mindful that their prime duty is to the court or tribunal, not to the clients who engage them to give evidence. And they should not give any professional opinion that does not accurately reflect their honest professional judgment or belief. These are not the standards for conflicts of interest per se, but it kind of shows that what the testifying experts are expected to perform their duty, and any personal or financial relationship that might undermine such duty could be considered as conflicts of interest. And next slide, please. Then comes the interesting part where in my first slide that different aspect of the client and fiduciary duty. I think this will be addressed later in the session as well, but briefly, there was a recent, like earlier this year, a UK court had blocked a consulting firm from providing expert witness service in an ICC arbitration over a petrochemical plant, finding that it was conflicted because an Asian affiliate of that consulting firm was already instructed by the opposing side in another ICC case over the same project. So, and the court basically found that the party appointed expert holds a fiduciary obligation of loyalty, which required avoiding the position where an expert's duty and his interest may conflict, and such obligation is owed by the full group, full global group, rather than the subsidiary only. So as opposed to the first three standards and rules that I mentioned, this addresses the party appointed expert's duty toward his or her client or the appointing party. So a slightly different perspective, I think, from being like independent for the whole tribunal and the integrity of the proceedings. So that's the final kind of the standards or rules that are in play when we talk about experts' conflicts of interest. So yeah, that concludes my short introductory presentation.
Thank you, Ara. Thank you very much. This is very helpful. I'm going to turn to Sarah if she has any comments on what does it mean to be impartial and independent as an expert, in addition to Ara's great introduction.
Yes, thank you so much, Ara.
Sarah?
That was a really excellent introduction. And what we can see in terms of best practices and standards is that there is a belief that experts should be independent and impartial. The interesting thing is when you do actually dig into the arbitration literature, there isn't necessarily a unity of view on that point. So some academics do actually argue that there is no need for an expert to be independent per se, but definitely the bulk of opinion says that experts must be independent. Now, certainly with respect to tribunal-appointed arbitrators, I think that that's undisputed. For party-appointed arbitrators, there is some divide there. But if we assume that the IBA rules are the general standard applied by tribunals, then yes, Article 5.2 does require that disclosure of any past relationship and does require experts to confirm their independence. Now, what we don't have from the IBA is any guidance on what independence means. And the problem that we see in arbitration, it's of course a melding of different jurisdictions, legal traditions, and from different countries, you really have experts approaching these issues with very different viewpoints as to what their obligations to the tribunal are, what their obligations to the parties are, and what their role in the proceedings is. So I think that there's some, definite value in revisiting these issues. I think that further guidance is needed on this point. Now, whether the way we should be looking at this is an IBA guidelines-focused way of looking at things in terms of relationships is perhaps another thing for me. It seems to me that, the way to approach this issue is actually about the substance of the opinion that's being provided and ensuring that the evidence that the individual is providing is actually independent and impartial, that it's not an advocacy piece. Now, you do definitely see this in some jurisdictions, and that's, I think, what we should be seeking to avoid, is ensuring that the expert is not acting as an advocate. Now, I liked Ara's question about whether we should be trying to apply the IBA guidelines on conflict of interest to experts. In the absence of other guidance, that's a fairly tempting thing to try to do, but I personally don't think that that makes sense. Arbitrators, we really need to hold them to the highest standards of independence and impartiality. And sometimes with experts, that's just not possible because parties need to present evidence on a certain topic and may not have a great diversity of potential experts from which to choose. So that's certainly the case in particular industries. It might be that a particular expert in an industry would necessarily have worked with one or both parties during the course of their career. And alternatively, if you're talking about particular jurisdictions, certainly here in Asia, it's a real challenge for us where we have a large number of relatively small countries, small markets. We may not have that diversity of expert that we'd want to be able to turn to in terms of regional or local expertise, but also language skills. So, my tendency is to think that trying to apply the IBA guidelines by analogies doesn't make sense in the case of experts. At the same time, of course, we should be leaving this, I think, to tribunals to assess the substance of the evidence that's being given and to assess the independence and impartiality. By and large, tribunals tend not to want to exclude evidence, tend not to want to disqualify experts, but they are generally very well placed to assess weight. Anything to add on that, Matthew?
I thoroughly agree. I think the key point that I would bring out of that very helpful introduction that you just gave is that the tribunal is in the driving seat in this process. It's the tribunal which has wide discretion as to which evidence it considers and the weight to which it gives that evidence. And to the extent that we agree prescriptive requirements as to experts' independence, we inevitably bite into that discretion of the tribunal.
And equally, I think that we also bite into the right of the party to present their case.
Correct, agreed.
So, as I said, in some instances it may be very difficult for a party to find a truly independent or strictly independent expert.
Right. I'm going to stay with Matthew and ask how common it is to encounter an expert who has conflict with either arbitral tribunal, one of the arbitral tribunal members, or legal counsel.
Thank you, Anwar. I can't hear you perfectly, but I believe that you asked me to what extent do these issues rise in practice. Is that right? So, well, I'll answer it. I'll do a classic lawyer's thing of asking the question I believe I've been posed rather than necessarily the question that's been posed to me. And in my experience, actually, and with the caveat that this is only my experience, but in my experience, issues of independence and impartiality do arise with experts. And I would say that around half of the cases that I have seen to a hearing have involved at least a strong critique of one or other of the expert's independence or impartiality. Now, whether or not that proved determinative in the tribunal's decision is quite another matter for reasons that Sarah has hinted at. And the reason for this is, again, for reasons that Sarah has already explained, that the world is small. The industries are small. The industries in which a dispute might arise and experts might be required is small. And the legal industry is small. So, for instance, if you're looking at experts on quantum evaluation, well, those experts form part of a legal community in Hong Kong and elsewhere. And it's quite possible that there will be repeat appointments and issues arising with respect to their relationship with counsel. So, to conclude, yeah, these issues do arise in practice.
Great, and perhaps I'll add to that. So, in terms of what I see, largely my experience is very similar to yours, Matthew. Relationships between experts and the tribunal I actually don't see commonly, and that may be an operation of the IBA guidelines on conflicts of interest, which do give prescriptive rules around relationships between arbitrators and experts. On the other hand, relationships between experts and counsel and relationships between experts and parties are rather common. Now, when I say relationship, I don't mean anything improper there, but repeat appointments do commonly occur, and especially in markets in Asia, where we have a smaller pool to draw on in terms of experts who may have the necessary language skills, boots on the ground, or experience in testifying. The pool is relatively narrow in many fields, typically quantum, legal experts, but also very technical, fact-specific, industry-specific experts can also be very challenging. My experience is that most of these issues are identified at the point that counsel engages the experts, so I typically don't see very problematic or troublesome relationships being exposed in arbitration, but there are often critiques. And I think that it is a useful tool to deploy together with a strong critique on the substance. So if you have a criticism of the substance of the expert's evidence, deploying that together with indications that he may have had a past relationship with a party, that can be very, very successful. In terms, though, of particular issues, I think that I'll go on to those in one of our later questions, but I can certainly give some examples of that.
Thank you. I'll just quickly excuse that I cannot really hear the on-site speakers very well. So in case if I miss any cue, please bear with me. Further to that, we'll stay still on the issue, how common it is, what the conflicts are. Lars, I would like to turn to you. Do you have any similar experience? What is it like in investment arbitration, for instance?
Yeah, thank you. I just to give maybe two concrete examples. So I fully agree with what Matthew and Sarah have said, but to give two concrete examples where it's very hard to find completely clean experts is, for example, when you need a technical expert in a very particular industry. So imagine you're looking for an expert in the nuclear industry in Japan. Then of course, all the people that have acquired their expertise, they will have worked for one of the companies that actually deals with the kind of nuclear in that country. And of course, then when you want to find somebody from the outside, outside of Japan, people just don't know about that nuclear industry. And then it's pretty clear that you have to go with an expert that probably has worked with one of the parties in question quite a bit. But then that's for the tribunal to factor in where it weighs the evidence rather than excluding that person. Now, coming to investment arbitration, I had an interesting experience where we were representing an investor against a Central Asian state that basically had developed its own laws, and we needed a legal expert. And so when we're contacting people from that state, they all told us that they were afraid to actually go against their own state. And when we asked the one professor that helped from outside of that country, that helped the state develop its civil code, that professor basically said, like, sorry, I can't help you because otherwise they'll never talk to me again. And so that is basically a conflict where you end up with having no expert at all, and you have to kind of start digging into the code of that country yourself and have to become an expert yourself. Now, staying on investment arbitration, what I just wanted to report on a quite interesting case, the Iser versus Spain case, because that involves a case that had recently been annulled. And the reason for the annulment of that case were found in one of the arbitrators having a too close connection with one of the testifying experts, where the annulment committee basically found there was a conflict in the sense that the particular arbitrator had worked too often with that particular expert when that arbitrator still worked as a lawyer in a law firm, and that this arbitrator had too many connections with that particular expert when he was sitting as an arbitrator. And so the cumulative effect of these two things made the annulment committee decide that this was basically a conflict that was so grave that it justified the annulment of the award. So I think, as Matthew said, when you have very small industries, or I think generally already this industry is quite small, but when you have even more specialized industries, the conflicts issues can become quite relevant.
Right. Thank you, Lars. Let's ask this. If we have conflicts, what can be the impact of a proven conflict on the credibility of the expert's testimony in practice? I will turn to Matthew for this.
Well, we've briefly touched on this already, and my view is this. It's of course true, and there is consensus among the speakers today, that expert testimony should be independent and impartial, certainly in an ideal world. And in fact, if you're cross-examining, or if you are trying to impute an expert's testimony, their independence and impartiality is, in my view at least, one of the key pillars on which they frame their conclusions, and which, if you eliminate, then you can bring their conclusions into doubt in the tribunal's mind. The other pillars are, of course, their credentials, whether they know what they're talking about, their assumptions, whether they've taken on board unnecessary factual or factual assumptions, and their methodology more generally. Having said that, in my experience, and I think Sarah's already made this point, simply knocking out one of the pillar associated with independence and impartiality is rarely enough. It's like, I'm going to go overboard with the metaphors now, but it's almost like a stool. If you have a four-legged stool, you could knock out one leg and the stool will remain intact. But if you start to impact the other legs, so in this case, if you can show not only a lack of independence and impartiality, but also that there is a critical and highly doubtful assumption which has been made, it's then that you start making headway and you are able to undermine the expert's testimony. So just to conclude that point, it can often be impactful if you can poke holes in an expert's independence, but only, in my experience, when you can also show issues with other aspects of their testimony.
Yeah, I completely agree. And, I do think that there can be a tendency amongst counsel to overplay their hand when they try to undermine the credibility of experts. Now, it's certainly important to question the credibility of an expert and to challenge that, but sometimes that can be overplayed. So to give an example, I'm thinking about one case in which we used a Big Four firm on issues of quantum. It turned out that several years prior, some 5 or 6 years prior, an affiliate of that particular entity within the Big Four firm had performed immigration services for the company in question. And opposing counsel tried to make something of this and something quite aggressive. They pursued quite an aggressive strategy. And that obviously didn't work well for them. It was very, very counterproductive. It was sort of tantamount to punching yourself in the face. So I think that, these attacks do need to be exercised judiciously. There can be a tendency in arbitration to pursue all avenues and to pursue them very aggressively, and often that tends not to work with a tribunal. It's important to focus on your best arguments. Another example of a very aggressive tactic that I've seen with respect to experts have been requests for production of all communications with an expert. Now, in that circumstance, it was a very time-limited arbitration, and we were firstly inclined to resist it on a point of principle. We considered those communications to be privileged. But on top of that, it was a time-limited arbitration, and we didn't think that it made sense to bring hundreds of additional records into the record, which would have potentially very much lengthened the arbitration. Ultimately, after it being pushed, we did produce those records because we didn't want to create any kind of apprehension of impropriety, so we happily turned them over. But after we then turned over hundreds and hundreds of extremely dry and highly detailed documents, the other side ultimately found itself overwhelmed and wasn't really able to process the evidence and get an expert report out in time, and that led to the settlement of the case. So it can be very unproductive to pursue fruitless avenues when it comes to experts. I think probably the best way to do this is to focus on your written submissions, really focus on how to counter the substance of what the expert is saying, and focus more on your offensive case and making sure that your own expert is strong, because I think that arbitrators will bring questions of independence into account when they're assessing the weight of the evidence, but hoping to have evidence knocked out entirely or discredited entirely is probably not realistic. Back to Inhua.
Thank you, Sarah. Let's ask this then. What good faith effort should counsel undertake when retaining an expert on behalf of their client to make sure that there are no conflicts of interest? I will ask Lars for this question first.
Yeah, I mean, of course, one could simply ask the expert whether the expert has certain connections with the client, the party. And of course, you can ask your client whether they have connections with the expert. What is often done, of course, is you don't necessarily do that, but you have internal lists. So we have an internal list where we basically list which experts we have used in arbitrations, and then we're careful that we don't use the same expert too many times, because that would probably give rise to conflict of interests. Another thing, and usually we do that on top of it, we'll send an email to the disputes partners and asking like, hey, we're now planning to work with that expert. Has anybody of you recently worked with that person? And then, of course, what's quite common is to have interviews with experts, and usually would be, you don't probably just choose one expert, but you kind of have interviews with a number, like 2 or 3, that you have identified on paper as suitable. And also during these interviews, things can come out where you say, oh, actually, that might be difficult if that would be raised in the arbitration. Maybe final point I want to make, which is almost kind of the opposite side of what you've been asking. There is sometimes a trend of proactively conflicting out experts. So basically making sure to contact a number of experts and trying to send them information about the case, where later can say, hey, you've already kind of advised me, even if I haven't chosen you, but you know too much about my case, so you cannot work for the other side. That is not totally uncommon. Interestingly, there is actually a bit of case law about it already, and I think Ara will maybe touch upon these cases later, but just wanted to mention in the investment arbitration sphere, there is a Bridgestone versus Panama case where this actually was a live question, where one party objected to an expert testifying for the other side, because that particular party had already reached out to that expert, asked him whether that expert could give testimony in line with what the party was seeking for, and that expert had declined, and later gave kind of the opposing expert testimony for the other side. And so there was a challenge brought against that expert, that he had already been conflicted out, so to speak. But that was ultimately denied by the tribunal, because the tribunal found there was not enough evidence to show that there's really sensitive and privileged information been handed over to that expert. So that is an interesting practical problem.
Thank you, Lars. Let me turn to Ara. What's your opinion on this? What's your take on this?
Yeah, thanks, Ina. I generally agree, yeah, with what Larissa just said. Like we would have to just make sure, like internally investigate and also to ask the client about, previous relationship or like how much we have worked together or so forth. And also from the experts or organization perspective, like they would have to do their thorough job as well. So interview, I think, is one of the practical ways to actually make sure that we have checked everything. Because like recently when I was doing an interview with a potential expert, while we asked initially to the firm whether they have any conflict, they said no. So that's why we went to the interview. But actual candidate kind of mentioned during the interview that he may have a conflict because he was approached by potential opposing party kind of. So I think that not sure exactly what was going on, but thought that it was, maybe it's just prudent not to give like too much information at the interview in case there is something unclear about the conflict status. And also, this might be an extreme like not a common case, but there was also an instance where we were asked to advise on what they should do because the party had an expert in one case, and then that expert firm merged with another firm which had conflict with the party towards the end of the proceeding, and they wanted to know what can they do. But I guess that kind of situation, I don't know how maybe there isn't a clear answer how we can prevent it from the time we retain the expert, but maybe there is more attention to be paid on the languages of the engagement terms to prevent any kind of those extreme situations.
Thank you. Sarah or Matthew, do you have any point to add further?
My only addition would be to make sure that when you do speak to experts and ask them if they have a conflict, don't use those terms. Be careful to explain what you mean by a conflict, and make sure to ask about any relationships that their affiliates may have with the parties, because that's usually where the problems arise. So an entity in one jurisdiction probably often doesn't assume that the relationships of its affiliate in another would give rise to problems, but that's certainly something to be very careful about.
And I've just got one point to add, which is that it's also helpful to, as a personal matter, to exercise a bit of self-discipline when it comes to appointing experts. It's very tempting, as with other areas of life, when something emerges in your inbox or you have some urgent matter to deal with or some urgent instruction, that you reach out to your expert of choice and run the arbitration as you've run the last 2 or 3 or whatever. And this is something I certainly see with my more senior colleagues. And by colleagues, I mean the term widely, as in other lawyers in the industry. So, in arbitration, sometimes you have to remind people that young practitioners, young experts, young lawyers do exist, and it can sometimes do quite a good job. And I'd encourage us all to reach out and test the waters, because they might not be, they may be more balmy than you think. Thank you, Ara.
Thank you, Matthew.
Sorry.
Matthew, I'm gonna stay with you. Let's think about a situation where the other side, when you are a counsel, when the other side expert has potential conflicts, what would be the strategic consideration of addressing the conflict to the tribunal? When in the proceedings, how would you have a practical insight into this, perhaps?
Yes. So for me, and again, this may be a function of my own experience only, but for me, the issue of conflicts has typically arisen most dramatically, almost emphatically, at the cross-examination stage. And that is for 2 or 3 reasons. First, it may be that a conflict has only emerged at the oral hearing stage. So, for instance, I've been instructed on cases in which the opponent's appointed expert was appointed to a non-executive directorship of one of his appointing party's group companies between the date of his expert report and the date of the oral hearing. And that obviously was only an issue we could come to terms with at the hearing itself. Also, despite the very important stipulations in the IBA rules and the CIARB guidelines, it's not always the case that experts do in their reports set out exactly what their relationship is with instructing parties. So what I find is that in cross-examination, it doesn't hurt at the beginning of cross-examination to ask a couple of open questions about that relationship. And it can reveal some surprising results. So timing is an important consideration. Another point is that at cross-examination and in the oral hearing, you have the guarantee that the tribunal is listening to you, that you have the tribunal's undivided attention. And I'd like to think that that's the same at the expert report stage, but it's not necessarily guaranteed. And the third reason I would say that cross-examination is a time to at least consider these issues is that cross-examination really allows the examining counsel to take this independence impartiality issue and run with it and direct it to other areas of the testimony. So for instance, I agree with Sarah that the examples she raised of her adversary's conduct were, shall we say, suboptimal. But what may be a better idea, especially if there's a genuine concern over the other side's expert acting as advocate, is you, through persistent, low-key, not over-dramatic or over-zealous questioning, you point them to their relationship and then perhaps take them through each of the occasions in their report where they have been faced with an opportunity of taking their client, an assumption in favor of their client or an assumption in favor of the other side, and where in each case they've chosen their client's case. And in that point, in that way, it's possible to direct a cross-examination so that you really reveal in a low-key way the way in which the expert is acting in effect as advocate. So that's my experience.
Thank you, Matthew. I would like to turn to Lars. Do you have any adding comments to this?
Not many more, because I think my other speakers addressed them really well. But I think in a sense, it's a bit of an expectation management issue to me. If you find that there is a conflict with an arbitrator, then I think your hope is that if you point this out and you challenge, you eventually, in a way, get rid of the arbitrator. And I think that's an expectation you shouldn't have if you find a conflict with an expert. I think it would be an extremely rare case where a tribunal would say, well, this person is so conflicted, we have to remove him, even though there have been cases like the Bridgestone versus Panama case where parties have asked for that. But the expectation should be a different one. It should be that the expert loses the credibility and the evidentiary weight for the tribunal, and that the expert testimony is disregarded. So I think once that is clear in the lawyer's mind and the client's mind, that this is a bit different than a conflict of interest for an arbitrator, I think then basically that's the way to proceed.
Right. Let's move to this aspect what we can deal with such potential conflicts now. what measures can we actually take if the expert from the other side has potential conflicts? Is it an option to file injunction? Is it practicable at all, or possible in every country? Let me ask this to Sarah.
Yes, I think that Matthew set out a good strategy for dealing with expert conflicts in the context of an arbitration. So first, I think raising those conflict concerns in written submissions and then pursuing them in cross-examination in a judicious manner is definitely the way to go. In terms of pursuing an injunction, I think as Lars said, your expectations or hopes here in the average case should not be that you're going to be able to ensure that this evidence is not adduced or that an expert is precluded from testifying in the arbitration. That's only going to occur in the most egregious cases. And, as Ara mentioned, there was a recent interesting case from the English High Court in A, X, Y, and Z, or A and B as it's been officially reported. That was a fairly interesting case, though, in that it was a situation where the claimant went to the English courts and succeeded in restraining the expert from testifying. And it was a case of a situation where an expert conflict had been created because of an affiliate relationship. So I suppose the interesting thing to say about that case is that the reason why the English court stepped in was focused very much on the duty owed by the expert in that case to the claimant. So in that case, the expert and claimant had entered into a confidentiality agreement. Certain fiduciary duties were owed. So this kind of case, it definitely doesn't apply in your average situation where you have a complaint about the relationship between your opposing party and their expert, which I think is typically the standard grievance in arbitration. In this case, it was a very egregious case where the claimant had a relationship with that expert's firm, had a confidentiality agreement in place, and was trying to enforce that agreement. By and large, any attempts to fully preclude experts from testifying are probably going to be destined to fail. In Hong Kong, we haven't been able to find any precedent of this occurring. There is no express power for this under the ordinance, and the ordinance itself does indicate that the courts are not to step in absent a specific power in the ordinance. That said, there is the ability to gain interim measures from the courts in connection with evidence preservation, and there is also the ability to obtain anti-arbitration injunctions. So it's possible in the future that these mechanisms might be used creatively in a very difficult case. But I think by and large, as Lars said, there needs to be a lot of client management around expectations when it comes to a client's concerns about an expert's conflicts of interest on the other side.
Right. I'd like to turn to Ara now for any additional comments on this.
Thank you, Ima. Not much to add. I think I agree with other panelists that it would be extremely difficult to actually even apply for the exclusion of certain expert based on the confidentiality, and there has to be a strategic decision, very difficult one to make in order to actually decide to pursue that route. And as Sarah mentioned, the recent UK case was slightly from a different angle. But I think upon my and in my experience, I didn't really have an experience personally, trying to actually exclude certain expert for on account of conflict issue. It was more of attacking the credibility through cross-examination, as Matthew mentioned. But just on research, there are some people say that maybe there is some argument to be made to say that certain expert should be excluded based on the conflict of interest. Some refer to, sorry if I'm I'm not sure if I'm pronouncing it correctly, but Hrvatska versus Slovenia, like 2008 exit case, where the tribunal has said that the counsel retained in the middle of the proceedings be excluded from the proceedings in light of the conflict of interest between the said counsel and the existing tribunal members. Some say maybe the same rule could be applied to the experts as well if the order of the experts, like after the constitution of the tribunal, and there is an apparent and clear conflict between the expert and the tribunal. But I'm not aware of any cases that has been successful with that theory. So yeah, I guess not. You can develop in a very situation where that's really necessary. But I think for now, I would say that there isn't there aren't many measures that you can actually take to exclude the expert after, like, in addition to just attacking the credibility.
Thank you, Aram. We have discussed so far about how to identify them, address them, how to best address them in the proceedings of the conflicts of interest involving the expert. I want to ask this rather challenging and intriguing question. Can we say that the arbitrators have the duty to investigate, perhaps not investigate, but at least inquire experts for potential conflicts? How should the arbitral tribunal deal with potentially conflicted experts if the tribunal finds such potential already without the parties addressing it? I'm going to start with Lars.
Thanks, Inwa, for offloading the real challenging question to me. Maybe to just pick up on what Ara said. I thought her pointing out the Hrvatska versus Slovenia, or in short HEP case versus Slovenia, in a sense is quite interesting, because if you match this case with now the Iser versus Spain case, and you say a party brings in an expert that basically has been testifying so often before a certain arbitrator or before a certain lawyer that it would give us rise to an annulment of the award, then maybe indeed the tribunal, knowing this, this information usually being in the public sphere in investment arbitration cases, might on its own motion say, well, this expert has to be excluded, because otherwise I or one of our tribunal members would have a conflict of interest, which would potentially lead to the setting aside or annulment of the award. So kind of picking off on Ara's idea, that might be one of the cases. Other than that, I think it seems quite tough to me to imagine that a tribunal would go and investigate by itself. I think the tribunal eventually probably doesn't have a duty to make this kind of investigation. It does have a duty, though, to render an enforceable award. So as I just mentioned, if there is a situation that threatens the award, maybe that's where a tribunal will become a bit more proactive. The issue, and maybe that's my final point, the issue about being too proactive is, of course, that if the tribunal starts investigating, that might be seen as going exclusively against one party, and maybe against the party's right to be heard or make its argument through that expert. And so it might raise equality concerns. So I would expect that tribunals will be very hesitant to ex officio investigate, and they will only do so where they see a clear danger for the enforceability of the award.
Thank you, Lars. I would turn to Ara for any further comments and input.
Yeah. So yes, it is hard to imagine a tribunal actually enforcing like ex officio investigating the facts, but from what we've been discussing so far, it occurs to me that maybe this disclosure of obligation is something that needs to be kind of enforced to make sure, you know, so that all comes from or starts from there, I guess, because we tribunal in order to make the determination on the credibility itself, like without going further to the exclusion, tribunal may need the information that it needs to figure out whether there was a conflict of interest. So maybe the one thing that the tribunal could think of if they want to make sure that experts are really independent in terms of those like other relationships or anything, then they could try to impose both parties to disclose certain like more like specific information regarding the experts. Um, but yeah, like Laura said, other than that, it's kind of hard to imagine like having the tribunal actually investigating. And yeah. So, yeah, that's
Thank you, Ara. May I turn to Sarah?
Sure. No, I completely agree with both Ara and Laz. I think that it would be considered inappropriate, and certainly from the perspective of clients in common law countries, it would be very, very objectionable if an arbitrator were to start conducting its own independent investigations. It would certainly encourage challenges to the award on the back end. I don't think that it's really necessary for a tribunal to engage in those kind of investigations. I think an experienced tribunal in these circumstances would probably be able to place a few judicious questions during procedural conferences in order to perhaps raise questions on that front with the opposing party so that that avenue could be pursued.
Thank you. Matthew, do you have anything else to add?
I do not. I fully agree with my panelists.
Thank you. I want to come back to Lars and ask if he has any other perspective from a German court practice.
Yeah, well, interestingly, when you come from German court practice, these issues of conflicts of interest, they're pretty rare, because in German court practice, it is usually the court that appoints the expert. And so in a way, of course, you avoid normally that an expert has too close connections to a certain party. So I think for a German judge, our discussion might be relatively strange and unfamiliar. Now, maybe one interesting point, possibly having been influenced by the German court practice, is the suggestion by the German arbitrator, quite prominent arbitrator, Professor Klaus Sachs, to have a kind of a hybrid version of what's going on in international arbitration and possibly the German court practice, which is the so-called Sachs protocol, where both sides basically submit lists of experts they could imagine being used for the case, but then the tribunal picks two experts of that list and makes them basically tribunal-appointed experts. And so, according to Professor Sachs, that's a bit best of both worlds. The parties, because they have suggested suitable experts, can feel comfortable that these people will be actually able to give expert testimony that addresses the issue in the case. But at the same time, since those two experts have been picked by the tribunal, they are not seen to be affiliated with any party and not to have necessarily conflict of interests. I have to say I've never used that protocol in practice. I've also haven't seen it put to use that much, which might be for the fact that maybe the parties, once this two-person expert panel is created, will appoint their own party-appointed experts still to basically control what these two independent experts do. So I'm not sure, but in the end you can avoid what's happening in international arbitration.
Thank you, Lars. You were speaking of a German court example that you actually don't see much conflict in the court practice. I want to ask Ara how it is in Korea and her experience with such conflict of interest situation in arbitration as well.
Yes, so it is similar in Korean court as well, that mostly it's court-appointed experts. So actually, when I started the practice of international arbitration, one of the newest things, like the things that I felt most different was the party-appointed expert. So putting it in a slightly different angle, actually, it's at first it was conceptually a bit struggling to find that the expert is party-appointed, but at the same time independent. So that's kind of a very different conceptual position that I think most civil law countries are taking in terms of the experts. So going back to like what Lars mentioned about Zach's protocol, I think like even if the experts are kind of with the opinion of some input from the parties, but still appointed by the arbitrators. But then as the working with those experts, I think the parties would feel different from what they would do with party appointed experts. So maybe that's one of the practical reasons why it's not really more prevalent on the practice. But I think it's one of the it's kind of interesting point from just Korean lawyer or Korean court practice perspective. Yes, it's like even going the conflicts between the party appointed what they say would be more considered like similar as counsel submission. So this kind of discussion on conflict of interest wouldn't really arise, I think.
Thank you, Ara. I want to ask Sarah and Matthew if you had any different experience from your common law background. Was there any interesting case that you've seen involving experts, conflict of interest issues in arbitration as well? Would you have any more stories?
There is one issue which kind of comes to mind, certainly when I consider what Lars has to say about the German system, which is that I haven't used this approach myself, but certainly I've heard of colleagues in the international arbitration community where there is a very high-value dispute and the independence and impartiality of an expert might come into question for a party to actually use the services of two experts. So the first would be an expert whose primary role was to assist in drafting of pleadings and framing the issues perhaps at the earlier stage of the arbitration and perhaps even preparing, for example, cross-examination of the adversary's expert. And you might call them the dirty, inverted commas, expert. And whereas the other expert may be the expert who testifies and whose name is on the report. And that allows you to get the best of both worlds, potentially. A clean expert who's clearly not acting as advocate for either of the parties, and the benefit of the knowledge and experience of your behind-the-scenes expert also.
Thank you, Matthew. Sarah, do you have anything that you would like to share, your personal experience?
No, nothing further to add.
I think with this, we could conclude our session today. I again apologize that I was cut off multiple times and I had trouble hearing acoustically from the speakers on site. I hope everybody still got the most out of this session. And I would like to ask everyone in your remote locations to join me in virtually giving them a round of applause for our great speakers. And I thank you all who joined us today, and I would hand my mic back to the organizers or Charlene. I'm sorry, news from the organizers. I'd like to ask closing remarks from each of the panelists, or is this conflicting input? I see that Charlene is back on mic. Please,
I'm happy
please
to give
go ahead.
closing remarks on expert witnesses on this panel. It was actually very interesting. Thank you guys for participating and bearing with the various technical issues that we've overcome. I still have Sarah and Matthew here, but they've come down. So I just wanted to thank also Lars, Ara, and Inwa for your time today. Particularly, I think this is the only panel where we really had multiple jurisdictions and different time zones. Thank you again. Have a lovely day, and we will be in touch soon. And for my participants, thank you for sitting through, or maybe watching, perusing through 4 very interesting panels today. We hope that you enjoyed it. My understanding is that because it was streamed on YouTube Live, it will also be available on YouTube. If it's a separate link, we will send it out to everybody. Nevertheless, we have all of the information on the Hong Kong Legal Week website. Now, last but not least, we have one wonderful closing remarks, which will not be from me. I know you are going to miss that. You've had me all day. I would like to take this opportunity to introduce the Honorable Teresa Chang, GBS SC JP, the Secretary for Justice of the Hong Kong Special Administrative Region, or Region Government, to deliver the closing remarks. Thank you.
Thank you very much. I'm so pleased to be here and to join you at the end of the session. I would like to perhaps start by answering the very question that was raised in the theme of this session. That is why arbitration evergreens do not get old. I think if you look at the participants and moderators, as well as looking at the subjects and the content of the discussions, you will gather from there that there is definitely a willingness to share, a dedication, and hence excellence in the work that they are doing, namely in the arbitration field. And I think the spirit of the Moot Alumni Association, who of course is one of the main organizers that have put this matter together. I understand from Charlene that there are about 5,000 members from around the world. And I'm so pleased that the Vis East Moot has also been participating and helping to set up this alumni and growing the alumni in the sense that there are many moots that are held in Hong Kong. And I'm also very pleased to say that the Vis East Moot is one of the bodies that is housed here in the Hong Kong Legal Hub. So we will continue to work very closely together in order to groom our young and evergreens. Now, I noticed today the 2 sessions are very interesting. I unfortunately have to admit I hadn't had a chance to watch and listen to it all on the live stream. However, I've picked up some of the points that have been made, and I'm very impressed with the depth by which people are talking about it. The first 2 sessions seems to me to be dealing with arbitration agreement. And of course, we all know that is absolutely fundamental, and that is why we are not just promoting here in Hong Kong, not just promoting dispute resolution, but also deal making. And when one does a deal, when concludes a deal, one of the last things that people normally think about is what happens in dispute. And that's why I've always liked to call the arbitration agreement as the champagne clause. That is the clause you add in before you open your bottle of champagne to celebrate the conclusion of the deal. And when doing this champagne clause or this arbitration agreement, I think probably I would be right in saying that there's three main ways. One is the simple way, where you just put arbitration in Hong Kong and leave it at that. The other may be the way by which you identify the institution, and when you do that, the easiest is to put in their model clause, their model arbitration clause, because all the validity arguments would have been well thought out. There is a third, which is always very interesting for lawyers, and that is when it is homemade. When it is homemade, you might come into the questions that you're looking at, the asymmetries question, the applicable law questions, which could create a problem when you actually have a dispute to deal with. And it is very advisable, I think, for one, therefore, to ask the litigation department of your law firm when you are closing a deal to get them to advise you on how you're going to conclude your arbitration clause, because it's only then that you will be able to make sure that the validity issues are not going to be a problem at the end of the day when you do have a claim that you wish to pursue. I wish just perhaps to share with you some examples that I myself have come across in my previous life as a private practitioner, as an arbitrator, and illustrates the importance of getting the arbitration agreement right. There was a case where the parties have agreed to do an arbitration, and the clause was very broadly put in. It is in fact under the IATA arrangements involving a national airline with another airline, and they haven't identified the place of the arbitration. And so as arbitrators, as one of the arbitrators, we wrote to the parties and we say, can you please identify where you want it to be seated? They come back and name a city in mainland China. And we know, or those of us who are involved in mainland arbitrations would know that ad hoc arbitrations in mainland is not acceptable, it's not valid. And so after a lot of sort of discussions, ultimately what they have done, understanding why they chose the particular city in mainland China, is because of the location of all the witnesses, all the documents, and everything else. We have to go and explain the importance difference between a seat, a legal seat, as opposed to a place. And ultimately, they chose the seat as Hong Kong, and of course, the hearing was conducted in the mainland. So that was one example where not thinking enough could be a problem. The second one, I would like to give an example that relates to how perhaps the arbitral tribunal approached the matter, is a case whereby the seat is a Hong Kong seat, it's arbitration in Hong Kong, clearly seat in Hong Kong, and then the clause said some English law to apply. Now that usually means only the substantive law. It was a maritime dispute. The arbitrator was appointed, the claimant's arbitrator was appointed, and the respondent did not respond, and therefore understanding or presuming that under English Arbitration Act, the claimant's arbitrator could become the sole arbitrator. That particular arbitrator then conducted and converted himself to be the sole arbitrator, conducted the arbitration, finished the hearing, rendered an award, and when that award was sought to be enforced, it was not enforced because it is a Hong Kong seat and Hong Kong arbitration ordinance apply, and we don't have a similar provision as the English Arbitration Act. So understanding the applicable law, not just by the parties, but also the arbitrator, becomes quite important. The other case that came to mind is the famous Pertamina or Caroja Bodas case, whereby they put in the seat of the arbitration in Switzerland, but then they have a very long applicable law clause, which again gives rise to a number of questions about how it's going to be applied, whether it is the procedural law and the supervisory jurisdiction. Now, these type of cases illustrate when it is overly simple without identifying the seat, or perhaps overly complicated when you try and write in your own provisions, could give rise to interesting discussions by resourceful lawyers. So I think the discussions today no doubt will help us all focus on the importance of the arbitration agreement. And of course, I think here also to say a word about ODR, which of course is becoming the norm everywhere in the world. There, what you need to do is still to identify the seats, even though everything is still done online internationally on the internet. But it's important to actually have a locale for the arbitration in order for the New York Convention to work. One would have thought that that would not give rise to any legitimacy issue relating to the arbitration agreement, but I think as cases develop, we will be able to see. Another suggestion, if I may, Charlene, is perhaps for MAA to consider setting up some drafting workshops for your members to perhaps share experience on how to draft an arbitration agreement, or perhaps put it in a broader term, dispute resolution clauses, because that will be quite useful, I think, in real life. The second two sessions I notice is on hot tubbing and conflict of interest, and the focus, I understand through what I've seen, is primarily on experts. I would like to use the phrase witness conferencing as opposed to hot tubbing for obvious reasons. And again, witness conferencing is an extremely useful tool, as you've seen in the demonstration, in trying to narrow the issues and help the arbitrator to come to his or her decision. My first experience, again, I think by sharing experience that might be interesting to you. My first experience came about maybe about 30 years ago, when people really doesn't even have the term witness conferencing or hot tubbing. And it arose inadvertently in this way. It was a case involving an Asian party and a Western party, if I call it that. And it involves PRC law as the applicable law, and one of the things we as tribunal will have to do is decide on the meaning of certain provisions of the PRC law. Both sides have called experts on PRC law to tell us what it is. And these experts are the top in their area at that time, and of course even more so now, who are giving the expert evidence. So during one of the tea break session, the two counsel came into our room and say they have a suggestion. And what is that? They say they felt a little bit difficult if they have to cross-examine the experts because these are very learned, very knowledgeable, genuine differences, as opposed to conflict of interest, taking sides type of experts. And so they suggested to the tribunal to ask the questions instead of them. We happily agreed to do that. So whilst with the two experts, one sitting on the claimant side, the other on the respondent side, the tribunal took on the questions that have been suggested to us, and in fact, of course, we have our own questions, and we started to ask them in the way that you have seen in what we now call a witness conferencing. Now, at that stage, we find it extremely useful because it helps us to immediately narrow the issue, as you no doubt would have discussed and appreciated in dealing with expert witnesses. Particularly useful, in my experience, on legal experts, but also in technical experts as well. Another experience I'd like to share with you, and you may wish to explore a little bit more, is that to use witness conferencing for factual witnesses. I've had that experience, and it turns out to be extremely useful. Now, the factual issues involved in the case, of course, could be complicated. But what I have done, because of the timing that we have to meet in terms of finishing the hearing and a number of other matters, the parties agreed to let us do witness conferencing by factual witnesses. So we have, I think, 2 or 3 witnesses on the claimant that covers a number of issues, and on the other side, roughly about 9 or 10 factual witnesses. What we did is we sit them all together, 10, 11 people sitting in front of the tribunal, and we, as you've seen in your demonstration, the tribunal asked the questions. And you would be amazed at how little differences on fact there actually were between the parties. Because after some questioning and clarification of why the witness statements say this or the other, it became quite clear that ultimately it turns on looking at the same fact, but perhaps interpreting it differently because of the way they look at the meaning of the contract. And so that exercise enables me to think that perhaps that could also be extended to factual witnesses, so that some of the time in trying to ascertain the facts through cross-examination may actually be reduced. But of course, all this should be done only with, I would say, more with consent of the parties, because these are still, in particular with factual witnesses, these are still generally new. As counsel, they would like to be in control, they would like to cross-examine. But as arbitrator, we would want to ask the questions we want to ask, because we want to hear exactly what it is that will help us in making the decision. So the practice of setting up a set of procedures by which a witness conferencing is to be conducted is extremely important, and it's very useful to start to work that out way in advance. Always, in my own experience, to start with questions from the tribunal, followed by questions on either side, on both sides, in order to cover questions that we as tribunal members may have overlooked. But that is a very important procedure so that everybody knows the rules and would not complain about not giving chance to ask questions and so on and so forth. The concept of conflicts that was discussed, of course, is also very interesting. It led me to think about the double-hatting questions that is often talked about, questions of whether one should be arbitrator as well as counsel, in particular in investment cases where the same issue, or generally the same issue, arise. And if you're arguing about it, will you as arbitrator be deciding in favor of the way you're going to argue, and et cetera, et cetera. I think arbitrator and counsel probably is less of a concern. But I pose the question of arbitrator and expert, because there are some who would give expert evidence as well as sitting as arbitrator on perhaps sometimes the same issue. I think with expert, my humble view is that it could be a little bit more difficult, because as expert, as you've heard the Chartered Institute of Arbitrators protocol, and indeed many experience that you have, the expert is to give the honest, independent opinion on a particular point of law. And when one does that, one does it on the basis of an honest opinion, not unlike counsel, where you sometimes are asked to argue a matter and perhaps to put it in a way, even though your honest opinion may not be entirely syncing with that. So I think when it comes to conflict of interest, it would be interesting to again explore a little bit along those lines. Again, a very interesting subject. And whilst here mentioning double hatting, I can also mention to you that tomorrow we have a session on sports dispute resolution, and sports dispute resolution under the CAS rules is exactly where they would not allow the arbitrator to act also as counsel in the CAS cases. So you see there are different rules in different sectors of arbitration. Now, to finally finish, if I may, say a few words about Hong Kong as well. We have the arbitration agreement discussions, and insofar as that is concerned, I think Hong Kong is a very, very good place to choose as the seat, because we have arbitration-friendly laws who will be able to uphold the arbitration agreement. And as I give the example, arbitration in Hong Kong would be a valid arbitration provision under the Hong Kong law and would not give rise to any problem. So Hong Kong has a very good legal framework for that. Recently, we also have the third-party funding that is in place that will allow parties to enable them to seek third-party funding in order to allow access to justice as well as efficient dispose of the matter. The third matter to mention, again, is I would like to call it a very important step in arbitration, and that is in Hong Kong. We have reached an arrangement with the mainland whereby an arbitration seated in Hong Kong and administered by one of the designated arbitral institutions, the parties to these arbitrations can apply to the mainland courts for interim measures. And we at the moment is the first jurisdiction outside of mainland to be able to do that. And that's a very important attraction for matters that are being conducted here that may involve mainland interests. Another matter, again, sometimes often overlooked, so forgive me for repeating the obvious to some of you, that our awards in Hong Kong are not only enforceable overseas under the New York Convention, but also enforceable in the mainland under an arrangement that has been signed back in 1999. So the awards in Hong Kong is fully enforceable literally anywhere in the world. And lastly, looking a little bit forward, we in Hong Kong are very much in support of law tech and strongly support the development of ODR in order to support dispute resolution, negotiation, mediation, arbitration, so as to assist not just the major parties, but also small and medium-sized enterprises. So I look forward to seeing you all continuously online in this legal week, and I thank the organizers again for inviting me, and thank you very much for organizing an excellent session this afternoon that no doubt have continued to keep the arbitration evergreens, keeping them not getting old. Thank you very much.
Hong Kong first introduced mediation as a voluntary resolution process under the Civil Justice Reform in 2009. Ever since that, Hong Kong has been at the forefront in the development of mediation in the region. From domestic to international, individuals to multipartite, and with the increasing use of technology to facilitate the process. Join me in the webinar series of the Hong Kong Legal Week to find out more about these latest developments, including the launch of the Judiciary's Case Settlement Conference Pilot Scheme, the application of mediation in investor-states disputes, sport-related matters, and ways in which you can improve your mediation advocacy skills. Hong Kong first introduced mediation as a voluntary resolution process under the Civil Justice Reform in 2009. Ever since that, Hong Kong has been at the forefront in the development of mediation in the region. From domestic to international, individuals to multipartite, and with the increasing use of technology to facilitate the process. Join me in the webinar series of the Hong Kong Legal Week to find out more about these latest developments, including the launch of the Judiciary's Case Settlement Conference Pilot Scheme, the application of mediation in investor-states disputes, sport-related matters, and ways in which you can improve your mediation advocacy skills.